On court today, Judge Simpson takes the bench. Judge Simpson delivers a blunt warning. You proceed at your peril.
Good afternoon, Your Honor. May it please the Honorable Court, David Burgess, currently representing Larry Lee.
Your name, sir?
Larry Lee.
All right. Mr. Burgess.
Your Honor, based on representations or communications I received from the court, Your Honor, I filed a motion to withdraw. I also received a letter today from Mr. Lee that the court made me a copy of, indicating he wants to represent himself. So based on the motion I submitted, as well as this letter, I'm asking the court to allow me to withdraw as his counsel.
And just so that the record's clear, the court received from Mr. Lee what were, in this court's opinion, I did not read them fully and only had a staff member relay them to me, were, I would say, privileged communication to the extent the privilege would still exist between Mr. Burgess and Mr. Lee. That is what I, based upon looking at them, what I presumed that they were. That is what I presumed that they were. At that juncture, I informed counsel that I had received them. Because I had viewed them as privileged, I had indicated that I would not let the people see them, but that Mr. Burgess could come by our office and look at what had been received. Shortly thereafter, I received Mr. Burgess' motion to withdraw, and basically that was going to be heard today. Almost immediately thereafter receiving that, I then received in our office mail or however it got to me, a letter from the defendant saying all kinds of different things, but indicating that he did wish to represent himself. That letter that he sent was shared with both sides. Today, I provided a copy to the people and also to Mr. Burgess in this case. All right. Is anything from the people?
Your Honor, just that I've spoken to Mr. Burgess about this matter. I don't have an objection to this motion. That's of course discretion. As far as I'm concerned, we've had communications about this case. He has fought diligently for his client.
All right. Mr. Lee, do you not wish Mr. Burgess to represent you in this case?
That is correct, Your Honor.
All right. And the other thing, you wish to represent yourself, or do you wish the court to sign an order that permits the Office of Manager Assigned Counsel to appoint counsel to represent you?
I would like the latter.
So you want new counsel?
Yes.
So you want at this time and I think it's on page 2 of your communication indicating that you wanted to represent yourself. You want the court to disregard that at this time?
Yes, sir.
You understand that because I'd be appointing new counsel, that's going to require that this matter be adjourned to allow counsel to get up to speed on your case.
Okay. I was unaware of that. Are we talking a 1 month or a 2-week adjournment? Just curious.
Well, it's wherever the court. I've got a very tight schedule, but we will. What day?
August 19th, Your Honor, would be the date.
It would go out approximately a month.
Okay. I have some upcoming surgeries, and so I will then like to just represent myself because I don't. They're very serious surgeries, and so I don't have the time to wait.
I understand that, but When do you think, if you represent yourself, when do you think your examination would be?
I would object to any further delays, and I would like as soon as possible, convenient with the court and everyone else. I'm prepared.
You're prepared to what?
I'm prepared to take the first available date for the examination as soon as possible.
Well, I don't know what you're asking me to do, Mr. Lee. Have you reviewed all of your discovery and everything?
As far as I know, the discovery was just 2 pages of the interview with the detective and the victim. And I have reviewed
I'm going to probably believe that there's more than just 2 pages.
Correct, yeah.
I just provided copies too, Judge. He was at my office on May 8th.
so I would need copies of that.
I mean, Mr. Lee, you're not, would I be correct that you are not prepared to go forth today to preliminary examination yourself? I mean, because you keep going back and forth, you want counsel, then you want that.
So I am prepared to go today. Absolutely.
If you represent yourself, you're prepared to go forth today?
Yes.
So what do you want me to do, Mr. Lee?
I would like to proceed today.
Okay, you understand that it cannot finish today.
Sure. I agree. That's fine.
Would the people have a witness they can start with?
Your Honor, we have a witness we can start with. I will say for the record, I do have concerns that if Mr. Lee is going to be representing himself, he's doing so without having all the discovery. And he, of course, will be held to the same standards as any attorney would be held. So a lot of concerns from the people, but we do have a witness available if that's what the court is inclined to do.
Is that really what you want to do, Mr. Lee?
Yes.
I think you're just, I'm going to be honest with you, I think you're just telling me yes, thinking that you're going to get a quicker date. And I am not clear that you're ready to go because you only talked about 2 pieces of paper and counsel's telling me there's a whole lot more in this file.
I understand. I'm willing and ready to go
Do you
today.
have a copy of the discovery?
My attorney hasn't provided me with a copy.
That's not true, Judge. I gave it to him on May 8th. He was at my office. He got a
Well, the
copy.
2 pages, yes, that's what I have.
No.
The other stuff I don't have.
Your Honor, for the record, not only is there a full police report, but there's also body camera footage that, again, it might be best to review before.
Have you seen the videos, Mr. Lee?
Well, I was there. I'm assuming they're referring to the body cam footage at.
Well, I don't know. You're making assumptions about what exists, and I don't know. Have you seen the body cam footage, Mr. Lee?
No. Have you, no.
Do you still? This way. Would the people be available? It is going to be a mess on the afternoon of the 8th. It's a Friday.
Your Honor, I should be available. And I have double. August 8th, Your Honor.
Yes, ma'am.
Yes, Your Honor.
All right. Are you going to be able to, so if I set it on the 8th, sir, and I'm sort of pigeonholing you in on a Friday that I normally wouldn't hold them, but if I do the 8th, are you still wishing to represent yourself or do you wish an attorney?
I'll represent myself.
Your Honor, the one thing I would like to add, because as I stated, we were ready to proceed today. The victim is here in this vendor meeting this morning. Victim has also been here previously for an exam. I would just ask that we have no further delays on the 8th.
Yeah, if I'm going to be done. If you're saying, Mr. Lee, that you're representing yourself and I set this on a special date, I'm not going to at that time. If you wish an attorney, then I'll have to deal with that, but I'm not going to let a delay happen. Okay. We're going to go on the 8th.
Yes, Your Honor.
Is that what you want to do?
Yes.
All right. I'm just,
We have a double checking.
pardon?
They works for the people and
All right. So that's what I would set. I will advise you at this time, Mr. Lee, you understand that you are charged with the offense of criminal sexual conduct in the 4th degree involving force or coercion. Do you understand that, sir?
Yes, sir.
And that involves a Stephen Kwanzi. You understand that, sir?
Yes, sir.
You also understand that this is a high court misdemeanor punishable by up to 2 years incarceration, a $500 fine plus court costs, mandatory HIV and STD counseling, and DNA was taken or should have been taken upon your arrest. Do you understand that, sir?
Yes, sir.
You understand also that this, under the SORA statute or sex offender statute, is a tier 1 offense and would require registration if the victims are 18 years or older. You understand that, sir?
Yes.
All right. And also other requirements, but I'm presuming that the victim is, that's the only one that would be applicable in this test, in this case.
Yes, sir.
You understand all of that. You understand that if you proceed to represent yourself, you do so at great peril, and usually doesn't not necessarily work well for people when they represent themselves, but you are constitutionally entitled to represent yourself. You understand that?
Yes, sir.
You understand also that the court is going to make the assumption or presumption that you understand the Michigan court rules and the procedures used in a courtroom. You understand that, sir?
Yes.
You understand that the court would not be there to assist you in any way regarding this case. You understand that, sir? And you understand that you will not be, the court is not going to treat you worse, and not going to treat you better than any attorney or the prosecutor in the case. You will be held to that same standard in conducting this.
Yes.
All right. Understanding all of that, you still wish to proceed representing yourself, sir?
Yes, Your Honor.
All right.
you know, just for clarification, does the defendant want to stand by counsel?
He has not asked for it. I'm not offering it.
I'll take one if it's available. Thank you.
Well, there's going to be a funding issue regarding that. I'll make that determination as to whether or not there be standby counsel, because that can be done elsewise other than this. I will adjourn the preliminary examination in this matter to August 8th, 2025 at 12 noon. That's before me.
Bond violation will follow.
Yes, there's that and the bond violation. Yes.
The defense is requesting, you to, examine the information between myself and my attorney, because I am alleging that I did not violate the, bond, the condition of the no contact order of my bond, and, witness tampering, that the prosecution says that I'm guilty of, and the text messages prove,
You're asking me to look at information that would be relevant to the bond hearing?
the text messaging between myself and my attorney, and then the Google AI searches that prove my motive and intent for making the phone call between myself.
Sir, and you're asking me to look at it in reference to the bond violation.
Yes, because I think it should be reinstated.
I will address that on the 8th.
Okay, thank you.
Okay, I'm not making a guarantee I'll look at it or not. I don't know whether or not it's relevant, but I will deal with that on the 8th. At this point, his bond will continue. Thank you.